In this lesson, we're going to cover the issue of improper purposes as being part of the illegality grounds for judicial review. We'll examine over the next few lessons the different varieties and actions and decisions that are taken which may be grounds for judicial review claims on the basis of illegality specifically. This lesson is going to spend some time examining the nature of where a decision could be taken for an improper purpose. Now, when we think about the idea of improper purposes, we basically come to the conclusion that if a decision is taken by some kind of public authority, public body, and it is done so for an improper purpose, then this can be a ground for judicial review on the basis of illegality. So you're questioning the reasoning behind the decision that is being taken. Is that reason a proper reason? Is that a proper purpose, or is it not? This is a question that you must ask. The case of Padfield noted that the discretion of a minister in the exercise of statutory authority has to act within the rules of the purpose of the act. Not to do so would be acting with an improper purpose. So let's think about this case then. Let's think about the case of Padfield. Padfield versus the Minister of Agriculture and Fisheries. This is a case from 1968 where the claimants had been milk producers and they had argued that the prices of milk ought to be increased owing to an increase in the transportation costs for that milk. Now, the price of milk was fixed by the, quote, Milk Marketing Board, which was operated under the remit of the Minister of Agriculture and Fisheries. So these milk producers argued essentially that there's been an increase in the transportation costs of this milk, so as a result of which there should surely be an increase in the price of the milk so that we make more money so we don't have to fork out revenue on the basis of the transportation costs. That's essentially the point. And the Milk Marketing Board are the people who essentially fix the price of milk, and this is done under the remit of the Minister of Agriculture and Fisheries. Now, under Section 19 of the Agricultural Marketing Act from 1958, another piece of legislation that I'm sure every single law student will be rushing to read from cover to cover, there was an obligation for the minister to appoint an investigation committee on the basis that transportation costs ought to be accounted for when we think about the price. So theoretically, if the transportation costs of milk increases, then according to Section 19 of the Agricultural Marketing Act, then there must be a way of investigating this such that the transportation costs therefore would be accounted for when looking at the price of the product. The minister refused to appoint such a committee, and they justified this decision on the grounds that it would cause economic difficulty if the price of milk were to increase. So they were making essentially a political decision, let's be honest, because if the price of milk increases, that obviously adds to the economic difficulty, and then there's the perception of a poor economy, and then when an election comes along and the manifestos are released, the opposition party will say, look, these people increased the price of milk. And when you think about it, it's those kinds of decisions, the day-to-day decisions of things like the price of milk, that ordinary voters are going to really resonate with more than more theoretical decisions or things like foreign policy, for example, because, of course, that affects everybody. If the price of milk increases, then for the most part, everybody is going to be affected by that decision. So there was a refusal on the part of the minister to do this, which was under their statutory obligations under Section 19 of the Agricultural Marketing Act from 1958. The House of Lords then held that a judicial review action can actually be brought on the basis that not appointing an investigative committee in this regard would frustrate the proper purpose of the Agricultural Marketing Act. So if you fail to fulfill your obligation as a Minister of Agriculture and Fisheries under the Agricultural Marketing Act, then you are frustrating the proper purpose of that piece of legislation. Quote, Parliament must have conferred the discretion with the intention that it should be used to promote the policy and objects of the Act. So there is discretion on the part of the Minister of Agriculture and Fisheries for them to appoint the investigative committee. But really, that discretion isn't unlimited. It's not unlimited discretion, because it should still fall within the remit of the legislation itself, the intent of the legislation, the objects of the legislation. And so if it fails to meet that obligation, then you are suggesting that there is an improper purpose that has been established here. The minister's decision to refuse to appoint such a committee, just on the grounds that it would increase economic difficulty, is an improper purpose for the use of Section 19 of the Agricultural Marketing Act. And so this passage essentially highlights the purpose and the nature of improper purpose. The idea that Parliament must have conferred the discretion when it comes to this piece of legislation for a reason. There must have been an intention behind it. And so if you have that discretion and you make a decision on the basis of that discretion, but you do so in a way that seems to contradict or go against the intention of the Parliament for creating the legislation, then it is implied that you are acting out of an improper purpose. Another such illustrative case is the example of the Crown versus Foreign Secretary. This is the World Development Movement case from 1995. And it's a case which illustrates that the idea of proper purpose of a statute, and therefore the extent to which a public body has acted within the remit of said proper purpose, is a matter for the courts to decide. The determination of proper purpose is a court determination. It was a case which involved the decision by the Foreign Secretary to approve aid in Malaysia for the construction of a hydroelectric power station. Now, authority to approve such aid would be granted in Section 1, Subsection 1 of the Overseas Development and Cooperation Act from 1980. This was a piece of legislation which essentially gives the Secretary of State, the Foreign Secretary, the authority to grant aid, quote, for the purpose of promoting the development or maintaining the economy. So, fundamentally, there is a reason for why a minister ought to be able to give aid to a particular, or to make decisions on the basis of aid and to approve aid for various different reasons. It is for the purpose of promoting development or maintaining the economy. The World Development Movement Limited sought to challenge the decision to grant aid to Malaysia for the construction of a hydroelectric power station on the decision through judicial review, that the cost of the power station was far more than expected. And so one of the things that the Foreign Secretary essentially found themselves stuck in this position was that the power station, they approved the aid, the power station was going to cost far more than expected, far more than probably the aid actually accounted for. But the Foreign Secretary did not want to pull out of the deal because they didn't want to risk a poor reputation abroad. World Development Movement argued that this is an improper reason for your discretion and your authority to approve or disapprove of aid under Section 1, Subsection 1 of the Overseas Development and Cooperation Act. The courts said the following. They held fundamentally that this decision did fall outside the scope of the proper purpose of Section 1 of the Act. And they say, quote, whatever the Secretary of State's intention or purpose may have been, it is, as it seems to me, a matter for the courts and not the Secretary of State to determine whether, on the evidence before the court, the particular conduct was or was not within the statutory purpose. So you could understand the Secretary of State for Foreign Affairs, the Foreign Secretary's decision and the Foreign Secretary's problem in the idea of pulling out of a deal for risking the reputation of the United Kingdom abroad. But at the same time, it is not actually the Secretary of State's intention or purpose that is what's at stake here. What is at stake is the intention and purpose of the statute, of the statutory purpose of Section 1 of the legislation. And in order to make a determination on what that proper purpose is, it is for the courts to decide that. It is a matter for the courts to determine whether, on evidence before the court, the particular conduct was or was not within the statutory purpose.